Good morning, everyone. We're just having a peek. It looks like Court TV is there with their own cameras, and I'm waiting for this to kick off so that we can watch it on the county website. And you know how this goes. Hurry up and wait. So we'll be here, we'll be streaming, waiting for this hearing to take place.
seated. Good morning.
Morning. Morning. Your Honor, may we have our client brought out, please?
Absolutely.
Thank you. Perhaps he's ready.
Okay, good. Let me tell everybody else, good morning. Welcome to Lexington County and to the Lexington County Courthouse. As soon as we get Mr. Murdaugh brought out, we'll get started. Mr. Waters, how are you?
Judge, how are you today?
I'm good. While we're waiting, let me introduce y'all to my new law clerk. This is my old law clerk. This is his last day. So you will not be emailing him anymore. This is Mary L. McKissick, and she will be the new law clerk that y'all will be getting emails from. So just wanted to introduce her so y'all would know when you did get them.
Your Honor, while we're waiting for Mr. Murdaugh, could I address one administrative thing? I've already talked to the clerk from Colleton County. When you file an order, on some occasions, you copy us when you file it. On some occasions, if we don't get it, the order allowing him to be pressed without the shackles. We read about it in Fitz News before we were aware there was an order. If you could, I don't know whether we moved over, but when you send an order to Colleton County, if you copy the lawyers, I think you've done that on every order.
Let me tell you, my office usually sends an order. I do that not only in this case, but any lawyer who appears in front of me. I send a copy of my own order. I apologize for that.
To apologize for, but once things crank up, getting it quick, getting it next day didn't bother us in this, but it may be that as you make evidence, whatever, it just, if you.
Absolutely. Well, I'll make sure that everybody gets a copy. Again, I apologize for that.
Nothing to apologize.
I usually do send it myself.
Thank you, Your Honor. Mr. Murdaugh.
Okay, you ready to get started then?
It's ready, Your Honor.
All right, well, let me just kind of do a little housekeeping here. Mr. Harpootlian, let me just address kind of what we did last time as far as making arrangements out at the Bureau of Prisons for a conference room where you could take discovery to your client. Have you had any issues with that?
Let me just confirm.
None at all.
I have no issues whatsoever. Everyone's been wonderful.
Okay, good. And then I told you that I would check on if there's any kind of download that you could do to the tablet that he has, and there's not. So we're going to have to stick with the computer from either the law clerk or one of your staff members going out to the BOP.
We are, at this juncture, we have a law clerk, this young man back here, who's going down there, of course, 2.5 hour drive. Typically it's 2.5, 3 hours with him and then 2.5 hour drive back. We understand. We're willing to put up with that.
Okay.
That's not a problem. However, we have retained some experts, and at some point we're going to need to, and they've done this in the past for us, but we've done some FaceTime meetings with them so they can show Mr. Murdaugh
I'm with you.
drawings and all those sorts of things. So we're going to try to, and I don't think they're going to have a problem with that, but if we arrange for an expert to be available and we're paying them hundreds of dollars an hour, we like it to work seamlessly if we can.
Well, if you have any problem, all you have to do is just let me know,
Yes, ma'am.
and we'll try to work around that.
Thank you, Your Honor.
Okay, we'll make sure it gets done. All right, if y'all don't mind, I've got how I want to do this hearing today. Because I plan to hear all of your motions except for 3. And I've kind of picked out the ones that I thought we could kind of go through right easily this morning. I know that both of you renewed your discovery motions and your reciprocal, discovery motions. Let me ask the state, um, right now, do we have any problems with discovery?
Not that I'm aware of, Your Honor. Obviously, we have filed a motion as it relates to that defense phone extraction. That's obviously one of the things on the table today.
And I'm gonna rule on that today.
We are obviously always auditing discovery, and of course, it has been a few years since the trial, so there may have been things that we would turn over that have developed since that time, and we're in the process of doing that, but we are not aware of any discovery issues at this time. Indeed, not too long ago, the defense realized that one of the original big murder downloads that we gave them back in August of 2022 had been corrupted on their end, and our staff worked and did hours and hours of work to re-upload all of that, to provide that to them. So my understanding is that they have all that, which they had then at the time. But they had
Yeah, certainly not anything new,
Not
just
anything new.
something you had to recopy
That's
and
right.
give to them. Okay. How about you, Mr. Harpootlian? Do you have any discovery issues right now?
Mr. Griffin would like to address that, Your Honor.
Mr. Griffin, be happy to hear from you.
Yeah, I'll come up here, Your Honor. Since I'm on the
Yeah.
microphone. Good morning.
Good morning.
I want to make a record. I mean, there's ongoing obligation by the state. They say that
There's an ongoing
They
obligation by both of y'all.
and so there's some items that we would have expected to receive by now, and we have not.
Let me know what those are. What are they?
So, as Your Honor well knows, the state has to produce evidence, information pertaining to, that the defense could use to challenge the credibility or truthfulness of a witness. It's called Giglio material, and it's in United States Supreme Court, Giglio v. United States, and these include plea deals and promises, even secret agreements, evidence of witness bias, and credibility issues of police where the evidence of past misconduct. And in that category, I have a few items as to secret agreements. There's a co-defendant in some cases, and then he's been charged separately. His name is Eddie Smith. Curtis Eddie Smith, who's a distant cousin of Mr. Murdaugh, was charged on November 2021, almost 5 years ago, of abhand, pointing and presenting, conspiracy, filing a false police report, and that's related to a roadside shooting that involved Mr. Murdaugh. Subsequently, in June of 2022, he was indicted by the state grand jury of 4 counts of money laundering, trafficking in meth, of other things. 4+ years have gone by, and those cases have not been disposed of. Every other case that we're aware of have been disposed of. And it begs the question, why not? Do they have a cooperation agreement with Mr. Smith? If so, what are those terms? He has been identified as a witness in this case since the last trial, well before the last trial. So we've got nothing on Mr. Smith. And if they have a deal, they're obligated to disclose it. If they have an understanding, they're obligated to disclose it, and we've never received it. With regard to credibility issues of police, we are aware that Judge Roger Young dismissed a murder case. And the name of that case is State v. Michael Colucci. And he was indicted in 2015. In June of 2025, Colucci's attorneys filed a motion to dismiss the indictment, saying that the state withheld critical exculpatory evidence on the eve of jury selection. The motions identify David Owen, SLED agent David Owen, who was the lead case agent in this case, who after this case received SLED Agent of the Year award. Judge Young dismissed the Colucci case because of withholding of exculpatory evidence. We want to know what's in Mr. Owen's SLED agent, I think he's retired now, in his HR file. Was he reprimanded? Was he sanctioned? Were any steps taken as a result of the Colucci matter? There's another SLED agent who was the lead SLED agent in the financial crimes case. Well, right now, we assume he's going to be a witness. He retired from or resigned from SLED. We don't know exactly under what circumstances, but then he went to work for the Charleston County Sheriff's Department. On June 8th, 2026, Captain Ryan Kelly was terminated from his position, according to the Sheriff's Department, for violating, for conduct unbecoming, harassment, improper procedures. And so that would be information. We don't have subpoena power unless we subpoena them to a hearing. They have control and can request this. We don't have it, and we would like it. And so, Your Honor, that's some Giglio material, some Brady material that we have, think we're entitled to. And as you know, Your Honor, Brady is evidence that is, could be exculpatory. We have learned through reporting from Fitz News that there was a recent murder, we believe, in Allendale County. And what has come out of that investigation and what has been leaked to the press is that Murdaugh murder weapons were connected to the Allendale County murder. Now, how could that be? And so we would like to know, were Murdaugh murder weapons connected to this Allendale murder? Now, if Your Honor will get into this, you'll learn that the SLED agent ballistic forensic lab did an analysis of just the shell casings on the 300 blackout that was used to murder Maggie Murdaugh. And the ballistics expert testified that the extraction marks on those shell casings found at the murder scene matched extraction marks found on shell casings around the Moselle home and at a shooting range. And their analysis was, in his opinion, it was the same gun that injected the shell casings of the 300 blackout at the house, at the driving range, and at the murder scene. Which leads us to, we don't know if it was the same murder weapon in Allendale, but if they did an analysis of the shell casings in the Allendale murder case, and they're saying it matches the shell casings for the Murdaugh murders, either their test is bad or someone's out there using a gun to murder other people. And so we would like that information. And then there's generally, we are aware that SLED has received tips, because we've received tips. We've not been provided any information about tips of whether it's reliable or not, identifying anyone else other than Alec Murdaugh participating in the murders. We've not received any information. Have they found the murder weapons? Have they found the murder weapons since the last trial? And there's related information underlying all of those. And so we don't think the state is taking their obligations seriously enough to find out what Brady materials out there has been developed and what Giglio material out there has been developed. And this is what we are aware of today, but we don't have the benefit. We don't have the ability to contact law enforcement and get this information. So those are our concerns.
Okay. Mr. Waters, let me hear from you on the Giglio.
Yes, ma'am. First of all, I want to say we take our obligations very seriously.
I know you do.
And never had a problem. This is the first they've raised these specific issues. They could have given me a call, and if I ever discovered anything of importance, they're the first people that I call, and that's always been our practice. As to Giglio, as to Eddie Smith, they, of course, there is no cooperation agreement. I don't have any secret agreements. If I had any agreement with the individual, I would disclose that to him. They have all the witness statements. They have the state grand jury testimony. They've had every bit of information that we have on, and every bit of discovery that we have on Eddie Smith. And there are no secret agreements. And if I do ever engage in agreement with any witness, I will disclose that immediately to the defense. I understand that obligation very well. Right. As to,
and those cases are still pending.
That's correct. Yes, sir. Yes,
okay.
Your Honor. As to Colucci and Kelly, we are all aware of our Giglio obligations. And as far as the Colucci matter, the judge, as I understand it, I wasn't involved in that matter, but ultimately dismissed that indictment just without prejudice, just to allow some additional information to be presented back to the grand jury that the individual said that he forgot. But there was no finding that he misrepresented anything. I have made inquiry, and I am not aware in any HR file of a finding of dishonesty or anything like that that would ultimately trigger Giglio. I have made those inquiries and I will renew those inquiries. And if anything is applicable there, I will immediately provide that to the defense, as we do every law enforcement witness in the case. The same thing with the termination of Ryan Kelly from Charleston. My understanding is
SLED agent.
he was a SLED agent. He went to Charleston County Sheriff's Office. And, you know, deputy served at will and he was terminated. But the inquiries I've made, and my understanding is that none of that had anything to do with dishonesty or falsification of reports or anything that would go to Giglio, that they were personnel matters. I will, of course, re-verify that. And if there's anything that needs to be provided in that regard, I will, of course, provide that to the defense. But that is my understanding at this time. And again, we always renew our Giglio inquiries for any law enforcement witness that testifies as we move to trial. And obviously, if anything's forthcoming, we'll provide that. But those issues are not there. As to tips, we provided a lot of that information before. But as I said, this case was tried, over 3.5 years ago. And so we are in the process of, correlating. Heck, I get emails from all over the world to this day, but we characterize or categorize those, and there will be any sort of information, no matter how fanciful and far-fetched, and that'll be provided to the defense as well. And so again, that, as you recognize and as we recognize, that obligation is ongoing. We take it seriously, and anything that has developed since that time, we will make sure to provide to that defense. We are constantly always doing discovery audits and discovery checks.
All right, well, tell me about the Allendale with
I'm sorry, Your Honor.
the murder weapons.
That's the first I've heard of that. I have never heard the first thing about that. If somebody told me that they had matched that to the murder weapon, not only the first call again I would be making would be to them, and the second call I'd be making would be to Your Honor. That is the first I've heard of that. I've never read the Fitz article. Certainly nobody at SLED, who I communicate with on a daily basis, has said, "Hey, Creighton, by the way, X happened." So I will certainly look into that, but I would be flabbergasted to find out that actually had happened and no one had advised this office of that.
Okay. All right. I hope that answers your questions. He's going to get back with you. He's going to double check on Agent Kelly. But to his understanding, there was no dishonesty, but that would raise the bar to Giglio.
Yeah.
But he's going to get back with you. As far as the murder in Allendale with the murder weapons, you certainly raised my eyebrows on that.
Your Honor, throughout this case, Fitz News has been breaking stories that we were unaware of, and we can go through a long litany of that. But there was a podcast. There's a reference to what I just said to you.
Maybe you could forward that to Mr. Ward and let him look at it and see if there's anything to it.
But we would ask that they look into that.
And I'll be the first to say, Your Honor, is that I don't watch the podcasts and I don't read the blogs. I try to base what I'm doing on the evidence and not on speculation that's out there in the media. But I've never heard of that thing, and I will make inquiries. But it would blow my mind if something like that had happened in SLED and not call me. I communicate them daily. Their general counsel sitting here in the gallery here today.
Okay.
But, and Your Honor, we would ask for the underlying documents on the Colucci matter involving judge's ruling, anything that was filed, anything related to the Colucci matter. And we'd ask
the one that's going back to the
20,
grand jury that was dismissed, that was referred back or dismissed without prejudice.
Without prejudice, just to represent to the grand jury is my understanding. And again, my knowledge of that case is very limited. All this really was publicly reported, and there's a public transcript in the judge's ruling, which is available to the defense.
Get it from the clerk's office.
Yeah.
well, we do have some materials, but we don't know if we have all the materials. And then, Agent Kelly's, documentation relating to his termination. I don't think it's just sufficient for him to say, well, I've asked and there's nothing related to misconduct. because what's publicly reported seems to be related to misconduct.
Well, there's a difference between what's in a personnel file that may be.
That's
fireable
exactly right. And
offenses.
there's a different
Yeah, go ahead.
avenue to go. When you're talking about law enforcement's personnel file, usually you can ask for them, but then they come to me. And then I go through them. And in camera, and if there's anything in there that I think that needs to be reported to both sides, not just one, but both, then I'll give it to you.
That's absolutely, Your Honor.
We'd love for that to happen here. Your Honor.
I don't mind doing that.
All right, thank you.
That's
Absolutely.
fine. You just, y'all need to get together, get them. I don't want anybody looking at them. It's not, I want them delivered to my office.
Thank you, Your Honor.
We'll
Okay.
get that done, Your Honor. Thank you.
All right, next, Mr. Harpootlian. I think this motion should be moot. I heard Judge Gergel dismissed without prejudice, and I think you have it on appeal, to modify the protective order for your federal case. Are you going to withdraw this and maybe refile it later after the appeal?
Yes, Your Honor.
That's what,
We filed it before Judge Gergel precipitously dismissed the case.
perfect. I figured that made this motion moot, and I could get rid of it. If you need to refile it, please feel free to do so
Once
after
Fourth
the
Circuit
appellate.
sends it back, we'll be doing that.
Okay. Then my next motion was the state sent me a proposed order for an amended protective order. This is by consent because I received your email, Mr. Harpootlian, that you consent. Mr. Waters, what I want to make sure is because, this is a new case. That means there's new filings. And in your motion for this proposed protective order, you listed a bunch of stuff. Is that included in all of this? Or was that just a history exhibit B that you gave me?
Yes, the Exhibit B just was for, this is a new case, but I just wanted to provide the court the sort of the historical development of the protective orders and sealing orders in this case. So you-
While we're signing it, why I'm signing it, and y'all are agreeing to it. Is that
Yes,
right?
ma'am. It was just for the court's information as to how things started, how they progressed through the first trial, and how they now set up for Your Honor.
Okay, well, if you both agree, I'm gonna tell you, I'm going to sign it. I also took the liberty of putting a consent for both of you to sign. If y'all sign that, I'll have the clerk file it and take it back, to Colleton today.
Want us to do it right now, Your Honor? Maybe we approach?
And I'm gonna give it to the clerk, and that one's done. Yeah. Thank you.
Thank you, Your Honor.
All right, now the next motion that I wanted to hear, Mr. Harpootlian, I did not get a response from you, but this is for the voir dire. It's a questionnaire,
Your Honor, we agree there should be a questionnaire.
okay?
But we think as this case develops, there's going to be additional questions we're going to want to have in that questionnaire. Now, what we did in Colleton, not that that matters too much, but what we did in Colleton was we had this questionnaire they filled out and mailed back in. And then when they got there was an additional, more case-specific questionnaire. We're not going to be mailing questionnaires to jurors until
January.
So we've got several months to deal with that. If you just give us to like the 1st of November to flesh that out, I think we can agree on a questionnaire.
Is that fine with you, Mr. Waters?
Yes, ma'am, Your Honor. We worked together last time to develop this questionnaire, and obviously I think we can do that again. And then if we have any issues, we'll bring them to the court.
Well, I looked at it, I thought it was great.
It worked very
Seems
well.
like it was helpful.
It
It
did.
worked great.
Your Honor, what we didn't address in the questionnaire, and we've got a consultant we're talking to about is, do we ask in that questionnaire a level of awareness about this case? I'm not saying we should, I'm just saying
Right.
we're examining that, and that's why I'd like till the 1st of November. And of course, in the question, if you do a questionnaire when they get here, obviously we want to know a little bit more about their specific knowledge of the case. But so yes, we agree there needs to be a questionnaire. We may want to add some questions to that questionnaire. We're just not sure, but we will be by the 1st of November.
What we did last time, Your Honor, that worked very well is we had that questionnaire. The parties went through that questionnaire. We actually then had a dialogue where we agreed based on certain responses of jurors to exclude. And so they were already gone by consent. So we already identified ones that would need additional questioning. And then, of course, there was additional questioning with the court and the parties in private for either jurors by their questionnaire or by responses in court that just needed further inquiry. And again, we were able to do that in 2 days.
And Your Honor, we would ask that there be direct supervision by you of the issuance of the jury summons, how they're picked. There were huge questions, obviously, after we learned of the clerk's conduct about how certain people maybe got on the Benari and others did not. She was apparently excusing people, we believe, and this litigation would help us. Litigation that's on appeal, of course, let us develop that. Her daughter appeared on the jury Benari, and she, and I guess at the time, either I or Mr. Waters thought that was unusual, but she was talking to both of us about how she makes a great juror. She talked to me, I know she talked to you. I'm not saying expecting that to happen again. We've got a new court, but in terms of summonsing jurors, there's a process. The Supreme Court, I found out later on, that there's a list. Actually, they're generated in Columbia, and then the clerk excuses before he or she issues those summons. There's a screening process. That's what I'm concerned about. In other words, the big list will come from Columbia, but how it gets narrowed down before we ever see it, that would be me
Right.
and Mr. Waters, concerns me greatly.
Again, this is the first that I've heard of any issues with that. I mean, my understanding is with Judge Newman's supervision, obviously a number of ones that were excused based on, patent exemptions such as over 65 who claimed that were non-residency issues and that sort of thing.
Right, would be my understanding of what normally happens
And when we
pick a jury here.
we had the whole panel arrive, yes, there was something like that. Obviously, she was excused. There were also people that had close relationships with Alec Murdaugh and the Murdaugh family. And of course, we vetted all of that and excused as appropriate.
Well, what was never done, and I tried to get the list, compare the initial list that was generated in Columbia to what actually were summons that were issued. And certainly there were people that the clerk said,
They don't live here. They're over
Right.
65.
dead, whatever. I get that. But if we never got the original list, so we don't know. And again, call me suspicious, but when we have evidence that the clerk of court is attempting to influence the jury to obtain a guilty verdict, so she could sell more books, when did that start? Did it start when she started winnowing down people she thought might be helpful to us? I'm not saying that could happen again, but I think I need to say to the court, I never expected it to happen the first time. I've been doing this 50 years. I've never seen a clerk of court interfere in this process. And clearly our Supreme Court found she did.
Okay. Well, I can tell you, Mr. Harpillion, I certainly don't mind overseeing it.
Thank you, Your Honor.
That's for sure.
And again,
Mr. Waters, I will, wherever this trial is going to be, I will certainly make sure that it is on the up and up. I can promise you that.
And just to be clear, there's absolutely no evidence that there was any shenanigans with that part of the
Yeah,
process.
I haven't heard of any of that, but, we''ll just make sure that everything is done properly.
Thank you, Your Honor. That's all I'm asking. And again, I would agree, we were never allowed to look at that piece of it for our motion for a new trial. It wasn't relevant to that. And the clerk was not, did she talk to any jurors? She was the court, both Gene Toll and the Supreme Court found her to be a horrible liar. So you have to prove it extrinsically. We don't need to go there. We may go there in our federal case, but we don't need to go there. I'm just saying, call me naive. I just want to make sure you are in charge of this process. And it's
Okay.
not deferred to some functionary.
No, I don't have a problem with that.
Thank you, Your Honor.
All right, the
Your Honor,
next
very
motion.
quickly, if I could
Oh,
just
yes.
say that as we got the dumps from the clerk's office with the jurors, it had the numbers on there with the over 65s and had the return from those individuals.
You
So
did get those?
That's my
We
recollection.
did, but the question is, who got off that list before we got it?
Okay.
That's the problem. And do we have any
You
evidence
just
of
want
that?
the original list.
I want the
is what you
original
want.
list, and I want
I
you to,
understand.
I want you to have the original list. So when summons goes out, when the summons go out, you know that everybody was on that summons list was summoned unless you were told they were dead or, and again, I'm a little paranoid after our last experience, not realizing the court was trying to fix the jury.
Okay. Well, I will, I'll make sure I speak with the clerk before that process.
And Your Honor, certainly Mr. Waters is not vouching for her veracity and truthfulness here today. I understand that we're here because she attempted to fix the jury, right? Am
I
missing
think
something?
I think he understands. Let me hear from you, Mr. Moore.
Well, look,
I
there
think
is
he
no, absolutely
understands
no
why we're
evidence.
here today.
You know, I went through a lot and actually, suggested a lot of these procedures. Ultimately, all we were trying to do, recognizing the uniqueness of this case, and there's no denying it, is get a fair and impartial jury. And,
Right.
and the process that we put in place worked very well. That actually the person who was handling all that and sending out those juror responses, it was, there was multiple staff involved, and all of that was under the supervision of Judge Newman. So we certainly understand what the Supreme Court ruled, but I know Your Honor will supervise whatever process, and my only goal and my only intent is to have the first screening process take place and then give us the jurors that are in play, and then we'll put together a fair process to put 12 in the box.
I agree with you, Mr. Waters. I'll take care of that. You don't need to worry. Neither one of you. All right, next motion is going to be the state's motion in limine to exclude evidence of the polygraph. Let me hear from you, Mr. Waters.
Yes, ma'am, Your Honor. This was just a prophylactic motion in limine that we filed prior to the first trial. And again, the case law is cited in there. I'm happy to detail it for Your Honor, but obviously the case law is very clear in South Carolina that polygraphs are a no-no, and that's because while they may be an investigative tool, the reliability of them is questionable. And of course, even the U.S. Department of Justice manual notes that it's not a lie detector. What it does is record physical responses that in the subjective opinion of the examiner may indicate deception, but that deception may or may not be related to concerns of guilt or innocence. And that's why the courts have always rejected those, in addition to the fact that they go to the heart of why we have courts and why we have juries. And that's, of course, for the ultimate determination of the truth of the matter. And so obviously from the state's perspective, if ever there's a polygraph issue or there's an interview that occurred after polygraph, we are rock solid to make sure that that witness and that, officer or whatever does not say the P word out loud. And that's just been the general rule. And and this is the way I do things, just like we did the financial evidence last time. We laid all our cards on the table, did a long, extensive hearing. There was no gotcha moments or anything like that. And we just asked for the same you mentioned, because, again, it can be hard to unring the bell.
That's right. Let me hear from you, Mr. Harpootlian or Mr. Griffin.
Please report, Your Honor.
Sure.
So generally, Mr. Waters is correct. But, and let me point out to the court, and I'll hand up a copy of the case. It's the state versus Henry, which,
It's the Eastwood case, is that what you said?
Sorry?
It's the Eastwood?
It's the Eastwood case.
I got a copy of it. Go ahead. No, I've got a copy.
So, as you know, if you've got a copy of it, the Supreme Court said there's not an absolute ban. There are circumstances under which a could be used. I mean, again, it is not a lie detector, but the question is, if somebody was confronted with the fact that they failed a polygraph, did they give it? I mean, in this case, did they give a confession? The Eastwood case, it was a confession gotten. In this case, and we want to argue this more fully, depending on whether or not this witness is called, Eddie Smith, who, as we've already understood, was charged with a whole bunch of stuff, had a proffer agreement with the state, and the proffer agreement was conditioned on him passing a polygraph. And as Mr. Waters knows, in other words, he had a deal, and the deal was predicated on him passing a polygraph. This is a copy of the results of that polygraph. And the polygraph was, did you kill Paul and Maggie Murdaugh? He failed it. And so they, relying on that, canceled his proffer agreement. Now, I'm not saying necessarily that's admissible on cross, but I am saying that it's an issue, not now, but much closer to trial, that we need to be able to litigate. And there may be others. We're not, again, we're going back through, I will tell you, Mr. Murdaugh passed the polygraph, flying colors. So the same polygrapher. So it may play a role in this trial. I'm not willing to concede that not under any circumstances can a polygraph ever be used. I'm just giving you this example of Eddie Smith failing the polygraph and them relying on it to cancel his deal. Now, that's what our understanding is from the limited documents. They never called Eddie Smith in the first trial, which we were shocked by. But should they call him in the second trial, we may want to go into this. But so I would ask you not to issue an order prohibiting any mention of polygraph with this guarantee. We would not mention polygraph in a courtroom with a jury until given permission by Your Honor to do so.
All right, well, let me tell you, anything else from the, Mr. Waters?
Well, Your Honor, just to correct one thing, there's some sort of deal with Eddie Smith. A proffer is not a deal. It says in big bold letters, this is not a cooperation agreement. It's only, essentially a first aid provision. Again, polygraphs can be an investigative tool, but they are never, I never base decisions on them. And frankly, in my experience, I found them to be wrong or indicate DI for other emotional reasons than they're not ever relied upon in court. The case that they cite is a different issue where in that particular instance, the defendant wanted the fact that he had been given a polygraph and was told by the he was lying as part of his defense in presenting an expert on, and that is nothing that we have in this particular case whatsoever. And in fact, if you look at the that we cite in the memo, Your Honor, a prime example of what the Supreme Court has was one situation, and give me 1 second, I'll find the case. That would be State v. Counsel, which is the seminal case on that. And in that particular case, there was a witness who took a polygraph on, were you present? Were you involved? And DI was shown, deception indicated was shown that because a polygraph cannot reliably show truth, no assisting to the jury because it doesn't show anything. So that's a vastly different situation, more akin to what we have here, where the Supreme Court has already said no, than the Eastwood case, where that false confession and this aspect of it was crucial to.
Okay, thank you.
Very, very briefly. There was and the proffer is, you're going to tell us stuff, and if you pass the polygraph, we go to the next step, which would be perhaps testimony. They were using it as a screening device, no question about it. But he failed the polygraph, so he didn't get the deal. He's right. He doesn't have no. And the reason he doesn't have a deal is he failed the polygraph. Now, whether we talk to the jury about that 9 months from now is an issue. But all I'm saying is we would ask you not to issue an order blank mention of polygraph, although I will concede I would not do that without having a pretrial, in-camera hearing of some sort.
Well, that's going to be my ruling, Mr. Harpootlian. The rule that the results of a polygraph examination are not admissible is the defendant's willingness or refusal to submit to a polygraph. And I'm going to tell you now, there is to be no mention of a polygraph test to the jury. This ruling is based on counsel and case and the Palmer case. Should the defendant seek to introduce any evidence or testimony or concerning a polygraph examination, you must and obtain a ruling outside of the present jury or risk this case being a mistrial. You understand?
Well, I think, Your Honor, you're probably threatening mistrial. You should start contempt.
Contempt. Yeah, you don't want me to hold you in contempt, Mr.
Well, I don't want you to
Harpootlian.
mistry the case.
I mistried if you start screaming polygraph. So without me know beforehand. You understand? I want to make sure everybody's on the same page.
I got it. I think I suggested it. I agree with you. I wanted you to know there are circumstances, and that's one where we may seek to do that. To do it without getting your approval, and
Perfect.
it may come up in the context of his testimony.
I mean, you never know what happens at trial.
Right.
I'm just telling, right now, I'm telling you, a polygraph is not admissible. If you're going to bring, you need to let me know first, and then we'll have an hearing.
Thank you, Your Honor.
Any objection, Mr. Waters?
None at all, Your Honor.
All right, the motion. The next is the state's motion in limine to allow the state's use of the defendant's testimony in retrial. Let me hear, Mr. Waters. I've done a lot of research on your motion.
Yes, ma'am, Your Honor. Obviously, at the first trial, Mr. Murdaugh, who of course had given multiple statements to the police, in which he said he had never been down at the kennels. He had told all his law partners, all his friends, all his family that he had never been down at the kennels either. And obviously, during the state's case in chief, we presented witness after witness who knew him very, very well, saying 100% that's his voice. Kennel video, which again was taken at the scene with the victims, and according to the timeline, just moments before they died. And so he ultimately, with the full waiver with Judge Newman, said, I'm going to testify and I want to testify. And of course, right out of the gate, the first series of questions asked by Mr. Griffin on direct examination was an explanation of why did you lie about being down at the kennels. It was the most important issue in the case at that point. Obviously, as a general rule, under Harrison, a defendant's testimony at a former trial is admissible, and I'll get to the statute in a second. And then I'll also, of course, under Rule 804A1, it would be admissible, of course, based on unavailability, assuming that he would refuse to or exercise his Fifth Amendment right at a second trial. The issue, of course, boils down to the statute. And of course, the statute says that the testimony of a defendant in a criminal case shall not be afterwards used against the defendant in any other criminal case except upon an indictment for perjury. And of course, our position in that is that this is the same criminal case. This is not an other criminal case. It's the same indictment. It's the same allegations. It's the same case that we are doing. There's no question that we are starting the evidentiary presentation again from new, but that doesn't change the fact in the plain language of the statute that this is the same criminal case. And we cite
That's the critical distinction for the statute. Either you're in the same case or you're not.
I agree, and we cite Tucker for that proposition. Now, I do agree that Tucker's a little different. It was a death penalty bifurcated case, and that the guilt phase was affirmed and the sentencing phase was reversed. But the court clearly said there that during the resentencing phase, that prior testimony was admissible because it was the same case. Now, the defense obviously argues that that because of the Supreme Court's guidance on the financial issues, that ultimately his decision to testify is somehow impelled by that, and we would respond to that in two ways. Number one is the first thing is it's very clear that the most important reason for him, quote, "I want to testify," is that he had to explain that kennel video, which again was the most important issue for the defendant to testify. Secondly, as we look at the opinion, and obviously I know you've deferred on the motive evidence, and we'll get to that at a later time, of course. But the Supreme Court, while saying that perhaps the trial court let the state go too far with that evidence, the court did say that the court appropriately ruled the evidence admissible under 404 and did appropriately admit at least some of that evidence. So ultimately, depending on how Your Honor rules on that motive evidence, admission of any prior testimony, should the state decide to do so, could be very much tailored to whatever the appropriate parameters are based on this court's ruling as to the extent of that testimony.
Right, I think it would go along with what financial crimes are allowed in at the time of trial.
Absolutely. Absolutely. And the state certainly understands that and is willing to do that. And then even aside from that issue, clearly, whether it's impeachment of this defendant, should he testify again, or if the defense were to present a new theory through evidence that would be refuted by this testimony, I think that the law is very clear that then it could be used for impeachment to sort of, if they change tack, then it would be fair game, regardless of the issue of the statute.
Okay. Who's going to argue that?
Mr. Barber will address.
Mr. Barber, come join us.
Good morning, Your Honor.
Good morning.
Of course, we oppose this motion on two grounds, a statutory ground and a constitutional ground. And I would like to address the statutory one first on the generally accepted principle that if a constitutional issue could be avoided, that you should rest on statutory grounds. And the statute here is 1911-50, which, as Mr. Waters said, prohibits using his testimony in another criminal case. And so we're concerned on what is the same case versus another case. At 10:23 a.m. in this hearing, Mr. Waters, standing at this podium, said, quote, "This is a new case." That was his statement on behalf of the state. On a different motion, he said, quote, "This is a new case." Now, for the purposes of this motion, it becomes, again, the same case. The defense's position is that a trial de novo is another case, that is the logical, rational conclusion from the statute, that the purpose of the statute is to protect the ability of a defendant to testify in one criminal case without a broad, irrevocable waiver of his Fifth Amendment rights. The state, as far as I can tell, takes the position that the indictment number controls whether this is another case or not anything substantive happening in a case. And I would point out that there's not a single case in which, with a trial de novo, because of an error by a state actor, not the prosecution, but certainly a state actor, that constitutes irrevocable waiver of the defendant's Fifth Amendment rights. Tucker is the closest case. As Mr. Waters conceded, it's not really applicable. It's a resentencing on the same conviction. Here we're having a trial de novo, and everything is new. As the court just went through with all those other motions, it's a new case. Even the protective order has to be redone. Everything is new. All the motions in limine have to be redone. The one thing that is eternal and cannot be changed from the previous trial is one witness's decision to testify. Is that Fifth Amendment waiver is the only thing, according to the state, that's not waived. For purposes of the statute, we suddenly become the same. And before getting to the constitutional infirmity of that, as Your Honor knows, we filed a motion to dismiss the indictment shortly after this motion. It was responsive to this motion. If the state, it's a reductio ad absurdum argument. If we're really going to take the position that it's not a substantive question whether this is the same case or a different trial, well, if it's the indictment numbers under thrift, we clearly meet the standard under thrift for dismissal in the indictment. Now, is that a waste of the court's time? I would say yes, because they'll just go to a grand jury and re-indict it. But if we're going to put substantive import on the indictment numbers, the arbitrary indictment numbers, well, the grand jury, we have testimony from the first trial that the grand jury was presented evidence that the state admitted in its reply closing argument was incompetent, which the witness also admitted was incompetent. We have, if you look at that very lengthy motion for sanctions that's still pending, it's a colorable claim of misconduct. I would point out in Thrift, the Supreme Court explicitly held there was no misconduct, but because there's a colorable case for it, which is the least possible burden. Well, fabricated evidence is a colorable claim of misconduct. Okay, is it prejudicial? Well, it would be the only direct evidence linking the accused to the crime, the only direct forensic evidence, something that would prove his guilt that must be prejudicial. So we meet the Thrift requirement. The indictment should be dismissed. They should have to go back and re-indict it. We'll get a different indictment number. It'd be right back here with a different case if that's really their position, that a trial de novo is not another case. And this is just a statutory argument. There is, of course, a constitutional argument, which is the Harrison argument, which is that because he was testifying to address evidence that was ruled to be inadmissible, that his Fifth Amendment waiver cannot be held in this new trial. I mean, that's the clear holding of Harrison. It clearly, in Simmons as well, which was a suppression hearing that in that case, someone testified in a suppression hearing and electing to assert that Fourth Amendment right in a suppression hearing, you're not required to waive other constitutional rights. The case law clearly holds, and Your Honor indicated that you've done a lot of research on this, that a witness cannot be required to surrender his constitutional rights to address inadmissible evidence. And I think Mr. Waters agrees with that, and that the dispute is whether or not he was testifying to address the financial crimes evidence. But as our response motion, with many quotes and block quotes, that was explicitly preserved. In Harrison, it was just an inference. In this case, counsel repeatedly put on the record why he was testifying. On page 3 of our response, Mr. Harpootlian said at that time, quite explicitly, put on the record that our advice as to whether to take a stand or not would have been different had the financial crimes information that he was also renewing the objection to had not been admitted over objection. And the court held in response to that the objection was preserved. So here we are. Harrison directly prohibits this, though I would suggest to Your Honor that the statute would be an easier ruling because there's no reason to reach a constitutional question. This is another case which we just said a dozen times when discussing previous motions.
Thank you.
Thank you, Your Honor.
Any response, Mr. Waters?
Very briefly, Your Honor. First of all, just because I just got this from General Counsel at SLED, that there was a 300 blackout that was used in Allendale. However, it was entered into IBIS, and there have been no leads or no matches on that. So that's what I was just informed.
Is that going back to
the prior motion?
to
Yes,
the
ma'am.
prior where the blackout was
And I'll find out more, but it does.
said to have been used in another murder in Allendale or somewhere? You understand that, Mr. Griffin? Okay. Sometimes a real novel idea is to pick up the phone and call each other and talk. That's what we used to do when we were younger. Just call and ask if you've got a question. And then if you have a problem with it, I'm more than happy to settle it for you. I hate that we have to do this in court. I do. It's easier now we can email you if you don't want to talk to each other. You can just email each other. Say, hey, you heard about this?
I have never not taken a call from these gentlemen. Love talking to them.
Yes, sir, Mr. Harpootlian.
Loves talking to me.
I did.
He did. So maybe you ought to pick up the phone and call him.
Maybe they need to start drug testing it. In all seriousness, I have never questioned Mr. Waters' integrity. But as a result of this case, I cannot help but question the SLED lab integrity and the SWED agent's
I
integrity.
understand, but see how easy it was for him to make a phone call and turn around and give Mr. Griffin an answer.
So, okay, and the answer is SWED entered it into some database and got no matches. Did they pull the shell casings from the Murdaugh trial and compare them to the shell casings to this? And that's not what I heard. That's not what I heard. And remember now, and if you've read the sanctions motion, they misled Mr. Waters about the blood spatter for months. And misled us and misled an expert. That was the SWED lab. And when we talk about DNA in a little while, that's the context in which we are approaching this case, because we were lied to. The grand jury was lied to by SWED, and he was lied to. So I appreciate the fact he calls, and I was a prosecutor for a while. Trust, but verify when dealing with police officers.
Well, I'm sure he'd be happy to do that for you.
I think I have personally been involved in the indictment of 7 sheriffs and multiple police officers. If I had any evidence, anybody intentionally fabricated evidence, I don't play that. There is a difference between, Mr. Harpoon, excuse me.
Let him finish.
There is a difference between where mistakes or the 2 ships passed in the night and intentional fabrication. That might be their characterization, but that's not what the evidence reveals. And obviously that'll be something that we'll discuss later on. But I will obviously look into that more. But IBAN is the database where you put guns in, kind of like the fingerprint database, and then it gives you hits whether it shows up with other crimes.
Would it show if you put in the casings or the markings from the casings?
I'm going to find out more and double check, and we're going to run this down. But again, there is no, from what was just told by SLED, that there are no leads or hits on that blackout that was used in the Allendale shooting. I promise you though, that I'm going to find out more.
And if you got any other questions, Mr. Griffin, just email him. He'll check it out for you.
Sure will, Your Honor.
And I mean, if you want some kind of verification, I'm sure he won't have a problem giving it to you.
As long as, again, a phone call between him and an agent who has a stake in maintaining his convictions is okay for him. It's not for us. We want to see if they submitted it, what was the result? Is there a written result?
And what I'm trying to tell you, Mr. Harpooling, is just ask him. I think he will give you just that.
Okay.
And instead of just throwing all these questions at him at one time, just send him an email. And if you want something verified, tell him. Do you have a report to that? I understand you being distrustful. I got it. But if he doesn't know what you want, he can't give it to you.
We'll be explicit. Thank you, Your Honor.
Yeah.
All right, let's go back now. I'm sorry about that, Mr. Orders. Let's go back to the defendant's prior testimony in his retrial.
Sure. And just to start out, he said at 1023, I said new case. And I think he's parsing my words a little closely when I'm talking about Your Honor's reconsideration of a ruling. It's still the same indictment. It's still the same testimony that under oath. It's still the same evidence that's going to be presented. It is the same case. And while Tucker is a bifurcated proceeding, it still was a brand new evidentiary proceeding de novo in that particular case. So I think Tucker is still applicable. Ultimately, again, I think that the appropriate solution is going to depend on your Honor's parameters as we get to that financial evidence. But ultimately, the Supreme Court said, we agree with the state that under the facts and circumstances in existence in the first trial, the trial court acted within its discretion in deciding not to exclude the evidence under 404, and went on to say, we hold the trial court acted within its discretion in admitting some evidence of his financial crimes. So that issue was in play. So it is not going to give them sort of a complete out, unlike Harrison, which I believe was a completely false confession that was played on TV and for everybody to see prior to trial. The financial crimes, according to the Supreme Court, were appropriately in play. The only issue was to an extent which Your Honor and the parties can clearly circumscribe that based on Your Honor's ultimate ruling as to those issues.
Okay. All right. I did, Mr. Barber.
Your Honor, just very briefly, we anticipated the argument Mr. Waters just made on page 9 of our response brief. It is under Harrison, it is the state's burden to show that its action did not induce the testimony. So this idea that you can parse out that they could have introduced some unknown quantum of financial evidence, we don't know exactly what would have been admissible or not, and maybe that quantum would have been admissible and therefore not triggered Harrison or Simmons. It's the state's burden to say that what they introduced did not compel his testimony, and simply saying that we perhaps could have introduced something is not sufficient to meet that burden.
All right. Well, I've read the case law. I've read the statute in this case. And I think it's pretty clear. A criminal defendant's testimony from a first trial is admissible at a retrial in the same case. And that is from 1911-50. The testimony of a defendant in a criminal case shall not afterwards be used against the defendant in any other criminal case. That is, our Supreme Court interpreted 1911-50 narrowly, and it limited its protection to the use in a different criminal case, not the same case. So I believe that his testimony may come in under 804. I've got B1 or A1, I think it's B1, or for impeachment purposes. The court does not find the defendant's argument prevailing. I think you rely heavily on Harrison versus U.S., where the defendant was forced to testify as a result of the prosecution using illegally obtained confessions by the defendant. Here, the defense argues that the evidentiary decision of the trial judge to allow evidence of the financial crimes coerced the defendant into testifying. However, I went and looked at the ruling again from our Supreme Court. The court ruled that the evidence of the financial crimes in this case is admissible in the new trial, so long as it is probative to the murders. Accordingly, this is inherently different as an evidentiary issue versus illegal conduct. Now, with all that said, I don't know, Mr. Harpoolian or Mr. Barber, what the state intends to introduce as in their case in chief. I don't know what financial crimes are going to be allowed in and what's not going to be allowed in. If it's not allowed in, certainly that testimony related to it. It's all subject to rules of evidence. If it's not relevant, it's not in your case in chief, then it's that prior testimony is not coming in. Obviously, I think you agree with that.
Yes, ma'am.
But I do think, when you testify in a case, there's consequences. Testifying and not testifying, there's consequences. You don't get to tell your story, but then you're also at the peril of cross-examination, and it's sworn testimony. So I'm going to allow it in, subject to what is being testified to in the trial. Okay?
Your Honor, for the record, we would respectfully
Disagree?
disagree. Are you going to issue a formal written order, or is that your ruling?
That was going to be my ruling.
And of course, we would renew it when it becomes relevant, but I just want to make sure we're not perceived to waive an objection to that.
Sure, I'm not going to let you waive any objections. You can take objections to all my rulings at the end if you'd like, and we'll put it on. It'll be on the record. We'll revisit it again at trial.
Thank you, Your Honor.
Okay. All right. Now, let me go to the state's motion as to the privilege review of the defendant's phone and the motion to compel defense to turn over the digital evidence.
Thank you, Your Honor, and may it please the court. Just to kind of set the table a little bit, and I know we have done so in our motion, the night of the murders, Mr. Murdaugh, although he was referring to his phone saying, see, hey, I called Maggie, see, I went, at that time, the phone was not downloaded. It was not until 3 days later on June the 10th that actually a 14th Circuit investigator, who's now a SLED agent, did an advanced logical download of that phone, of course. And so there was that. And then later on, after the side of the road happened, or I think it was maybe in August, excuse me, then his phone was seized again, and there was a download done by SLED at that point. Okay. Obviously, he's a lawyer, and like any case where we have a phone, but particularly one where there's a lawyer involved, we had in both instances the first one was done prior to the Attorney General's direct involvement, but there was a privilege review done in order to protect the rights of the defendant, right? And so ultimately, the investigators only and the prosecutors only received the redacted parts of that phone, whereas the defense always got the unredacted copies with everything on it.
Right.
Same thing happened with the SLED download. It was privilege reviewed by a taint team at SLED, and then the investigators and prosecutors only got the redacted portion, of which thousands of messages were excluded. The defense got the unredacted portions as well. So the first part of this motion is, and I believe they consent, so I'm not going to talk too long about that, is that since that time, of course, there's been a number of developments, and we painted a broad brush because, frankly, Your Honor, the last thing in the world I want to do is to become privy to some communication I'm not supposed to. In fact, we go through great lengths to ensure that doesn't happen. But we've since had, I think, 12 attorney-client privilege waivers from former clients of his. He, of course, has pled guilty to conspiracy with another lawyer and a banker. And so those things, I think, would require a reassessment of that privilege because of either attorney-client fraud or these waivers, and so we proposed to do that with the taint team, and then we also proposed, and I think they agree to this, that we would identify new communications to be released to the prosecution and investigative team, but give them a chance to review those without us seeing them and make any sort of issue they want, and if there is an issue, we'll bring it to the court.
Are these waivers, are they affidavits, or what are they? Or
Yes, during the course of the financial investigation, many of the clients executed written waiver, attorney.
okay, so there's a written waiver from these clients.
That's correct. Yes, ma'am, Your Honor.
Any objection to that being sent back to OGC and reevaluated?
No, Your Honor, we don't object to the process that was described in Mr. Waters' motion, where the taint team would bring to our attention and the court's attention any potentially privileged stuff before the prosecution receives it.
Okay.
All right. The next part of this is that early on, of course, we were told that there was a defense extraction that had been done. We've now, since their response, they've said that it's a logical extraction as opposed to a full file extraction. The thing about phones is that they really represent a snapshot in time, right? They are, I hate to use the word breathing, but they're sort of living items where the evidence on them can change through manipulation of the phone and just how they operate from one day to the next. And so ultimately the defense had that extraction. We never asked for it at the prior trial. They, of course, never used it and didn't call the examiner who did that. And so we filed this motion to ask for it. I think, for the sake of right now, I think the defense has raised these constitutional objections while we have our arguments where we believe these things can be authenticated other ways and that there would not be an act of production Fifth Amendment violation. At this point in time, I'm going to state that I think a better solution might be, because under Rule 5, of course, the disclosure obligations require them to disclose that. The problem I see, and why we ask for this, that usually be easily set, overnight, right? Because they are very large. And so what I would suggest and request of the court is that, and I understand that during trial things can change, but that there be, and ultimately there a scheduling order whereby at least it's this issue they can declare that intent, or at least give this information if they're going to use it to the state in a reasonable enough time prior to trial, so that we're not broken down with the jury on ice, so that we can assess a phone dump of 256 gig phone.
All right, so you agree that they don't have to turn it over to you unless they're going to use it in their case in chief,
I think
unless it's provided that it's not protected by attorney-client privilege. It's
I-
not protected under the Fifth Amendment.
Well, I think what I'm saying is we raised arguments as to why the Fifth Amendment would not apply in this case, why attorney-client privilege and work product would not apply in this case. And again, we're not asking for the opinions of the examiner or the impressions of that. But what I am saying is at this point in time, given their consent on the privilege review, am not willing to, push us into this particular thorny issue at this time, as long as maybe we have a remedy that if they are going to use it, it is provided to us in
You
sufficient
want
time.
notice.
That's correct. Yes, ma'am. I think that's a fair resolution.
Any problem in giving him notice if you're planning on using anything from this phone in your case?
No, Your Honor, we didn't use anything the first trial because the full extraction the state did less than a month later has that and more. So I don't anticipate that we would use it at all, frankly. We didn't.
All right, well-
I have no issue with giving notice if we change our mind.
Well, let me ask you this. I set the trial for April the 5th and I intend to stick by it. How about, if you're gonna use anything, can you turn it over to him by March 1st? That'll give you like 30 days to have any rebuttal or expert witness or any objection to that?
If Your Honor if this is only about the Chip Johnson cell phone extraction that we're talking about, if that's what's subject to that notice requirement, there's no objection.
Thank you, Your Honor. That's absolutely acceptable. The only other thing I would just ask, and I'm sure they would do that anyway, is that as we work out these issues, that any extraction be preserved during the course.
March 1st deadline. Okay,
I
March
think that
1st.
takes care of that issue, Your Honor.
Perfect. But we're just going right through these. All right, let's talk about the DNA. This is the defendant's motion. This was brought up at the status conference. The way I left it was to find out if there was any a viable sample to test. And I want to make sure I got this right. It looks like there was really two samples, a sample the state tested, and there's some leftover, for a lack of a better word, leftover stuff. I don't know that it contains all DNA in it, but leftover. Then there's a reserve DNA sample. So I want to make sure, because there's two. Am I correct in saying that?
Yes, ma'am. So these are, of course, the fingernail clippings.
Right.
And so you got the clippings in the package. As I understand it, a representative sample was prepared and tested. And from that, there's 47 microliters of extract remaining. And testing can proceed from that. There is also, though, the reserve portion of that sample itself that has yet to be processed, which
The same sample.
the same set of
Same,
fingernail clippings.
right.
But it's kind of like a shirt, or pants. You get the pants, you do cuttings from it. You don't cut the entire thing. And so there's still, parts of the pants that could potentially be cut and tested and that sort of thing. So it's very
Right.
similar. So we have extract, and we also have the unprocessed sample. And so what we have, and we've had a discussion with their expert, and he said, that's barely even a mixture.
But he's talking about the leftover stuff though, right?
He's talking about the remaining extract, correct?
The leftovers.
And we're willing to let them test that extract, even though he says it.
The leftovers.
Correct. But what we would want is at least some recognition to them, because he said it's going to be consumed, that's going to be gone. We have preservation of evidence requirements and all the rest of it.
Are we still talking about the leftover stuff?
And then on the unprocessed, what we have said is that we will process and quantify that and then stop. Okay. And at that point, we will know the quantification. We will also know the likelihood, which is highly likely, that there will be leftovers from that, from which the defense could have that as well. And so we're willing to do that in conjunction with and in discussion with the defense and their expert, which is an extremely fair way that all parties have access to all.
I read your motion. I was just, Mr. Griffin, you arguing this?
Yes, Your Honor.
I just wanted to make sure that they're willing to give you the leftover stuff. That's how when I read it, I'm like, okay, there's 2 DNA samples are all from the fingernails. They want to give you the leftover stuff, but then they want to go and do a quantitative test on the unprocessed sample.
Correct.
And then decide what to do with it. If maybe y'all could share it,
right,
or do I have to give it all to you?
So that, and in that conversation, we asked, to what end do you plan to use it? And we've gotten no answer.
Okay, well, I'm gonna get to that in just a minute.
And so our expert says the whole quantitative analysis, it does consume some minute portion. So they would be consuming the minute portion. At Othram, they do the exact same thing. If they got, and to be clear, Othram has in the past, and I'm sure will in the future, they receive DNA samples from SLED. They're in chain of custody. They have routinely test.
From our lab?
Yes.
So there is a way, because that's one of my questions.
And so, and they're
Maintain a chain of custody.
absolutely certified to do that. They do that with law enforcement around the country. And Your Honor, I just watched recently the Idaho murder documentary
I
on.
watched it.
But Othram is right there. I mean, they are the lab who does this, and it's
That was going to be my next question to you. I mean, are they an accredited facility?
100%.
I just can't be handing over DNA to somebody who's not
They,
accredited and they know what they're doing.
and when we were on the phone with him, and he says, we work with SLAD Lab, and they receive samples from them. They do that work. They do it work, on behalf of cold cases around the country, and they do some work on behalf of the Innocence Project. And so they are certified, and there's been no dispute about that. And they, what Dr. Middleman says is, what's their scientific purpose for doing quantitative analysis? What are they going to do next? Because we'll do quantitative analysis and we'll share that with them. And then we'll give everything back to them when we're done.
And we're talking about the unprocessed.
Both. We're talking about both.
Both.
So there's, leftover extraction that was processed.
Right.
And we want to test that. And then we want to have the unprocessed and to do a quantitative analysis and then include that in the testing. I mean, and the question is, if you're doing STR analysis of the same DNA sample, why do you think anything different is going to happen? I mean,
Well, let me ask you this. If Othram is willing to process it.
Yeah, absolutely. Quantitative analysis and give it before they do it the next step. I mean, we'll do that and we'll share it with them before we do anything further.
Is there, can they do the other tests, the STR testing?
I'm confident they do STR testing
They can do the STR and the SNP.
and the SNP testing. Yes, they can.
And that's what,
And we also,
and let me make sure I got this right, because the SNP is really different from the STR. Those results are based and compared against like CODIS, known samples.
STR is.
The STR. The SNP is a bigger, I want to say a bigger database because it's
Well,
genetic. So like all the people who
23andMe.
23andMe and all the other,
If you or I or anybody in the
agencies.
courtroom gets a sample, submits it to 23andMe, that's a SNP analysis, and that uses a whole lot more of the genome, a whole lot more of the DNA.
not that it's going to give you the one individual, but what it might give you, and no guarantees, is a family tree that you might can trace back. Is that right?
Absolutely.
Okay.
And in addition, what Othram can do, so we do know that this sample, this is male, the unknown male. So there's Y chromosome in that sample. Othram can test and analyze that Y chromosome, and depending on how much it is, they can go back to origin. Like, is it an Asian? Is it a white male? Is it, I mean, and they're able to do that. And so they have so much more capacity than the SLED lab. And it's expensive, and we're wasting time, and we want to pay for it, and we want to get on with it.
Well, I already told you I'd let you pay for it. That's a given. That's going to happen. How long is it going to take them to do it?
Well, we put in our supplemental memo that it would take 60 to 90 days. I mean, honestly, he says, we'll make it a priority. We can do it in 60 days. And I said, well, how about, don't say that. Let me say 90 days. But what we'd like to do is have it all at one time so we can do it all at one time.
I understand that. But let me ask you this. What does your expert say about having something left over that they can give and share with the state? Do they think if they had it all, is there something going to be left over to give to the state? So they want to do their STR test again.
So we would know that, Your Honor, after the quantitative analysis that we would like to author them to do. And then we would like to share that with the SLED lab. There's no reason, because they're doing the same thing. And Othram says, why?
Well, if you're going to share the STR results, you're going to share the SNP results.
Well, Your Honor, I didn't say we was going to share any results. I mean, I said they could do that. The rule doesn't require us to share results of scientific analysis unless we intend to use it. But
Right, I agree with you on that. But I'm asking if they wanted you volunteering to do the STR, which they want to do also.
well, I'm not sure they want to do that, Your Honor. I haven't heard that. I've said, to what end do you want to use this after doing a quantitative analysis? Well, what are you going to do with it? You're going to do the same thing twice? You expect a different result? I promise you they're not going to do that, because then that would pretty much cause their lab to be, the credibility to be challenged at that lab. They do the same test, get two different results. I mean, we're talking about the same sample, Your Honor. We're not, and they know the mixture. And they tell us the mixture is 99% Maggie Murdaugh and 1% unknown male. So, I mean, they've got that information, but we'll do the quantitative analysis. We'll come back and, share that with them. And then, if they, I don't know that, we want to do STR.
But you can't tell me that you can share it with them because you don't know yet, because we don't know how much is there to share.
Right. And so what I'm saying is we do the quantitative analysis, then we would know, have an idea of, if we're going to use it all or not. I mean, they didn't use it all when they took their sample. And so there's extract. There will be extract that can be sent back. And Othram will work off the extract that they mix it with a mixture. They put it in their DNA, holding devices, and Othram will do the same thing.
All right, let me hear from you, Mr. Waters.
Thank you, Your Honor. This is, first of all, the first time that I've heard that they said they would share. In fact, what I was told expressly was that they would not share anything to start out with. But
Well, I don't think they want to share the results with you.
All right.
okay?
Yeah.
Is what they're saying. However, you know, if they want to do the STR, I think I'd make them share the results with you on the STR. They want to do the SNP for themselves, and they don't have to share it with you under the rules of discovery,
Okay. Well, and so first of all, I was
unless
informed.
they use it in their case in chief.
Right, and hopefully with sufficient notice. But my understanding is, and I was just, texted this, is that they are not accredited in STR. They are accredited in the SNP testing.
Okay.
But to explain what this is, and so it's kind of, there's a bag full, as I understand it, and this was recently explained to me, there's a bag full of, the little fingernail clippings, okay? And they pick out a representative sample and put it in a tube and shake it up, and that's from what's generated. And then you have the remaining portions of that item that are in that bag. And so that's what needs to be processed. So it's not a question of necessarily doing the same thing over. It would be like taking a different cutting from an item of clothing.
Right. You might have a little bit of DNA over here, and then you might have it on the other side of your fingernail, a little bit more.
Correct. And so there is the chance that there could be something that comes out differently. And so SLED can turn around this quant in a couple of weeks. And again, there's nothing to indicate, and this is what I suggested, is that we would do the quantification and the processing and stop. Okay. We're not going to proceed forward with STR on it without calling the defense and letting them interface with their expert. And at that point, we'll know, which is probably likely, that there'll be enough for SLED to do STR or YSTR, and there'll be enough extract for them to do what they want. But their own expert has indicated with the quantification for the leftovers that it's 3 alleles. He's like, that's hardly even a mixture. It's over 99-1. He's like,
that's the leftover.
Right. That's true. But he says there's
not the unprocessed. They want it all, so maybe they can get something to test.
And I am happy to facilitate that, but we have to have a fair access to that second half as well. And that's what we're offering to do, and to do that with the defense. So again, SLED has the burden of proof. SLED, or the state has the burden of proof.
Well,
SLED has custody.
You can't tell me either that if you prepare the reserve sample, that there's going to be enough for them to do the SNP test.
What I can tell you is that we will do the processing in quant, and that will stop. And that's when we will know. And then we can discuss that. Is there going to be enough just for STR? Is there going to be enough for one? If that's the case, then we can talk about that issue. Or what's more likely is there's enough for column A and enough for column B, but there's going to be no prejudice to that if SLED does the processing in the quant, and that's what I proposed to them, which is fair to both sides, and we will stop and have a conversation with them before proceeding so that there's no prejudice to either side.
Let me.
Now, they've had 5 years, and we're on appeal for a while, but from 21 to 23, they did all the testing they wanted to do, and now we've come up and asked to test it, and guess what? Oh, we want to test it. Well, they've already tested it, and now because we asked to test it, they want to take control of our testing. I mean, that's not fair.
Well, I got it. Let me ask you something. Do you know if you can do an SNP and an STR test from the same sample?
I don't know the answer
The
to that, Your
SNP
Honor.
first and then do the STR?
I personally don't know the answer. We
You
can find
know,
the
Mr.
answer out.
Waters?
We can find the answer out. But
I'm sorry, Your Honor.
I was just wondering if he did the SNP, the SNP test first, can you take that same sample and do the STR?
As I understand it, we have to process and get the quant, and then we will have an idea of what sort of sample that we have. And then, as I said before, then we can have a discussion with the defense and see, what we have and whether there's enough for this, that, or the other thing. And we can have a discussion. And again, I'm here to be completely fair, and this is a fair process for both sides. And if there's a dispute, then we can come back to Your Honor. But I think SLED, who has custody of this evidence, should do that processing and that quant, at which point we will stop. There will be no prejudice to either side. We'll know what we're dealing with, and we can talk to Dr. Middleman. We can talk to the SLED lab and say, is there enough for column A and enough for column B? And I want to correct something.
Let me ask you this. Are you expecting a different result from your retesting of this sample on the STR?
I'm not expecting a different result, but there's always the chance, just like if there was a different cutting from the same clothing. or a different part of the swab. It's just, it's always a chance. But that's why with best practices, and I gave you the memo, that reserve sample is kept. And then we're talking about fundamentally burning it all up, and that's fine. It is best practice for a law enforcement agency, particularly with the Preservation of Evidence Act, to keep stuff in reserve. But if we're gonna burn it, then it needs to be burned in a fashion that is fair to both sides. We can rush job this quantum processing. There'll be no prejudice to either side. Stop there, and I'll talk with the defense. And if again, Dr. Middleman already said with the 3 alleles and the leftovers that there's unlikely that he can do anything with that. But we'll have that conversation.
We can do the quant analysis and share it with them, Your Honor. We can do the quant analysis.
Give me just a second. If Altham is accredited to do STR?
He says they're not. I don't know the answer to that.
And Your Honor,
I would accept that they're not, but
Okay.
I need to correct. I think I said they're not accredited in either STR or STP. It's just STR. They're not accredited in, according to what I'm advised.
Okay, that they're not.
Yes, ma'am.
but they are in SNP.
Okay.
I was also advised as well that because of the FBI accreditation standards for law enforcement, that SLED has to run the processing first. So it really needs to go consistent with their accreditation, needs to go from SLED to them. But that's why we're willing to stop and again do nothing without any prejudice. But their general rules are it can't go the other way based on the accreditation and the FBI standards.
Have any response to that? He's saying that if I let you go, let Altham do the analysis first, that then their STR won't be accredited. You know anything about that?
I don't know anything about that, Your Honor, but let's step back and look where we are. We're at the defendant. He's asking for this. Who can
I
complain?
understand.
It's only us. And we can't complain if the court orders SLED to do something that we've asked for. I don't think it jeopardizes SLED's accreditation because in one single case, which they've had.
It's not often that I get the defense asking for DNA. That doesn't happen very often.
Well, there's a lot in this case that you're going to find out doesn't happen very often, but this is one of them. And so, Your Honor, that they do quantitative analysis as part of their accreditation. I mean, it's not like they're doing something that's outside Otham's accreditation. I mean, they are.
Let me ask you, I mean, what harm would it be? Because if I give you the leftovers, they've already done the quantitative analysis on it. Is that right?
Give them the leftovers.
If I give you the leftovers and let them do the quantitative analysis on that and then hand it over to you. So whatever left over, they did the quantitative analysis, you could give back to them and they can do their STR. What's wrong with that? That way they can keep their accreditation for their STR. I'm just trying, what if he gets a different result? And he wants to use it at trial. And I'm trying to make sure you get your snap test. And I'm gonna make sure that you get it.
You know, and from talking to Dr. Middleman, he says to me, what's the scientific purpose, or do they want to do this? What's their next step? If there's no next step, then there's a risk when you do quantitative analysis that it will get destroyed. And why take that risk? Now, first time I've ever heard him say, and you talk about we need to communicate, I've emailed him, we've had conversations about this, and I've said, what's the scientific basis? What do you plan to do with this once you do this thing and stop? And today, for the first time, he says STR analysis. I've not heard that before. But
I thought I saw it in his motion. Did I not,
Yeah.
Mr. Waters?
And also in an email to Mr. Griffin as well.
well, I overlooked that too, but
I can find it.
You know, it's not like a piece of paper. I can make a copy of it.
Right.
You know, and it's just such a little amount, and I'm trying to make sure. I want you to have your test.
well, certainly we can get the leftover extraction pronto. That would get us moving.
And Your Honor, if I could, this is an email to Mr. Griffin, Harpootlian and Barber and associated folks from July 21st, 2026. In which I stated, as we also discussed, I plan for SLED to process the reserve portion of the 70 and 71 samples where we can get quantification, at which point we would stop and consult with the defense on quantifications and the likelihood of remaining extract before proceeding with STR or YSTR. However, as I told you, I've paused that process while we discuss the matter. This is a fair process for both sides and one I'm willing to work with you on, but I should point out, Dick made it very clear that the defense would not even promise to turn over results if reserve sample or extract was sent to you. I'm happy to discuss this further and ensure a fair process for both sides.
But you know, you would agree with me, Mr. Waters, that he doesn't have to turn it over to you unless he's going to use it in his case.
Well, I will say this, that if we're talking about, you know, that's why we need to process the reserve unprocessed sample. And then we can figure out and almost certainly there's going to be enough for column A and column B. But I'm willing to do that and stop and then have a conversation with them. And that's what I've offered. That's the fair result. It doesn't prejudice anyone. And of course, the quantification is going to, you know, determine how much material we have. And at that point, the scientists can analyze what is likely and what is reasonable. And I'm willing to involve them in that process. We just got to get to step one, and SLED can turn that around in just a couple of weeks. And then I will stop and give them a call and we'll hash it out. And I'm 100% willing to make sure that there's no prejudice to either the state or the defense.
Your Honor, to respond to that email, we discussed it. You have to understand the context. Before we tried the last case, they indicated there was blood spatter on a t-shirt. We wanted to examine it. We wanted to have it tested. SLED violated every rule known to man and destroyed the t-shirt in the process of processing. Now, it turns out that they also, when they processed it, determined it wasn't human blood. We didn't find that out till very late. But the point is, we want Optum, who is the gold standard, to do the quant piece. They want them to take that piece they've had for 5 years. Did they check it to make sure the first one was right 5 years ago? No. Now, when we have Optum, oh, we better check that. So make sure we didn't screw this up. This is just a CYA. This has nothing to do with seeking justice. So I would say, let us have the unknown sample, had been processed. Let Optum quantify it. Let them, and if it's not going to result in them losing their certification, don't test it. They've taken 5 years and not tested it. Why should we run the risk of them screwing that up? That if we screw up the quantification, we accept that. If they screw it up, we don't have a sample.
I understand.
And that's why I'm so passionate about it, because we went out there to SLED. We dressed all in, Mr. Waters with it. had on lab coats and went in there and examined the thing and took pictures and then, you know, we couldn't test it. I don't have any faith they won't screw this up. But you know, whether you have faith in them or not, why don't we have an independent right to examine the untested DNA? Why don't we have that?
Your Honor,
Except there's some procedural issue about their certification. We have a right to a fair trial. We want to.
Yeah, you have somebody from SLED here that can tell me about, if I give them this sample, you can't do an STR?
we do have Lieutenant Stanley from SLED.
Come up here and speak with me, but I'm gonna put you under oath. Madam Clerk.
You solemnly swear or affirm that the testimony you give the court is the truth, the whole truth, and nothing but the truth, so help you God. I do.
Okay. All right, well, tell me how you lose your accreditation if I give them a sample and then you like take the leftovers and, yeah, you can go right there at the podium. And you can't produce an STR that could be admissible in court. Is that what you're telling me?
Good morning, Your Honor. I am the quality manager for the laboratory. So my job is our accreditation and making sure that we are complying with accreditation standards. The DNA laboratory is accredited by the same entity as Othram, but in different capacities. We also follow the FBI quality assurance standards, or FBI QAS standards, that are put out by the FBI for DNA caseworking or testing laboratories, as well as DNA databasing laboratories. In order for us to accept data from, or accept a sample from another laboratory, they need to be accredited in the same services for us to continue our testing. So it's not necessarily losing accreditation, because we just wouldn't be able to accept it and perform the testing.
Well, let me ask you this. What if you got a sample and it was the only sample you had that had already been processed? Just hypothetically, are you going to tell me that you're not going to do an STR on it and try to admit it into court?
We may not be able to, is what I would like to tell you. We share samples with Othram, for example, or third-party laboratories, but we're typically giving them the extract or the remaining portion, and they're able to work with that for their samples. We are unfortunately not able to work with theirs.
Why?
I'm not as familiar with the SNP testing, so that might, my understanding of that is it has to do with the standards that are followed for the accredited laboratories.
Okay. All right, thank you. Mr. Griffin, let me ask you this. If I give you the leftovers and I give you the unprocessed sample, you have it quantitative and you do your SNP test, and then you give them the leftovers and they can do their STR test, would you consent to it being admitted into court?
Yes, Your Honor. We wouldn't raise any objection as to the
To accreditation,
accreditation, chain
anything
of
like
custody,
that?
thing like that. Now, if there's some other irregularity in the process, sure, but not because of it flowed from Othram back to SLED. No, we would not object to that.
Okay. Anything else from the state?
Your Honor, just as to that last hypothetical that Your Honor stated, I think that the same thing would have to happen, that after processing, you have to stop, because only then are you going to know whether there will be leftovers. And that's the whole, what I'm proposing is we process and we stop. And at that point, we'll know whether there's going to be enough for STR on SLED and enough for them to have the leftovers of that. And that's exactly what I'm saying. But if they go ahead and run the SNP without consulting with us, there may not be any leftovers, is what I'm saying.
Well, let's talk about that, because why even get it processed if we're going to stop? Then what's going to happen?
So we'll know at the quantification point, we'll have an idea at that point that if we proceed with STR testing, whether there will be, like there was in the other examples, 47 or however many microliters of extract remaining for then to be provided to Othram, which again, the original leftovers were willing to provide. But the processing in the quant is where we kind of know what we have and what if we do further with it, do actual testing with it, what is the consumption possibility at that point. And so that's why I'm proposing that we process it, we'll know what we have, and then we can actually have a discussion of who can do what with what. And that's what I'm proposing to do, and have SLED do that. We can turn around in a couple
Well,
weeks.
this is their motion to do their SNP test.
Sure.
And that's what I intend to rule on today. Not get halfway through it and come back and hash this all over again.
I absolutely, Your Honor. But once we get that quant, then we will, and their expert will know exactly, first of all, is SNP viable? And secondly, the amount of consumption that will be necessary for that. And so that's why we're not kind of like stopping. We're just, I don't know.
What is your position if the SNP test destroys the whole sample? There's nothing left.
So Your Honor, what we want to do, we want it all to go to Othram. The unprocessed, they will process it. They'll do a quantitative analysis, and we'll share that quantitative analysis with SLED. And then we'll know whether there's enough to do both. If there's not enough to do both, they'll know that, we'll know that. But and we want to do the SNP testing with that. We may have to be back here and having the same back and forth. But what we don't want is SLED to keep it, SLED to do a quantitative analysis and then say there's not enough for you to use. I mean, that's what we don't want.
That's my whole offer, is I wouldn't proceed without having that discussion and with him. So that's the whole point of what I've made, is that we'll know what we have at that point. I'm not going to do anything to prejudice anybody, but we got to process it to know exactly what we have and what we can do with it.
And we want to process it.
I understand. Mr. Griffin, I'm gonna grant your motion. I'm gonna let you, take it. The leftovers, the new, y'all make sure you make a chain of custody. I'm gonna let you, have the analysis done, quantitative, then I want you to report back to the court and tell me if there's leftovers before you do your SNP test. I want to know beforehand, and then, cause I've got to get this started. You need 90 days at least. So we need to get it started. I want you to report to the court, let me know. And, then I'll have a discussion with y'all on what we're gonna do.
All right, thank you.
Okay?
Thank you, Your Honor.
Thank you. All right. Just gonna hold up and let me know. All right, let's talk about transfer of venue. Who's,
Your Honor, before you do that, we have a 5-minute recess.
I'm sorry, I have a bad habit of keeping right on going. Absolutely, we can. Court's gonna be at recess for, let's say, 15 minutes, so I can give everybody else out there a break too. All restrooms are located on each floor in the same place, over to the right. And thank you.
Thank you, Your Honor.
the last one, right? Well, he's just got that McCullough thing, but I don't know why we even have to be here for that. We should be excused.